fundamental. Y toma la palabra el presidente del Consejo Notarial, don José Ángel Martínez Sánchez.
Muchísimas gracias, decano. Es un honor participar en la inauguración de esta cátedra y para agradecer a ICADE que nos hospede y nos albergue y su colaboración, porque verdaderamente en estos temas creemos que es fundamental reflexionar sobre la evolución que en este mundo representa la digitalización, y ninguna casa mejor que la de San Ignacio. Ahora me gustaría recordar efectivamente las meditaciones de San Ignacio, donde venía a decir que meditar consistía en traer a la memoria una verdad para mover luego la voluntad, y nos prevenía de la inconsciencia en que vivimos rodeados de un mundo cada vez más tecnológico, sin adentrarnos en las consecuencias que puede comportar para la vida humana, para la sociedad y para el derecho. Porque esta cátedra, aunque está auspiciada por el Consejo General del Notariado desde el principio, tiene en su ideario su carácter horizontal y abierto al diálogo y a la reflexión entre todos los operadores jurídicos, y movida fundamentalmente bajo la idea de que la seguridad jurídica no es un concepto o un valor distinto o incompatible de la justicia, sino la forma de que ésta se lleve a efecto. Y este finalmente es el fin que en todo momento persigue esta cátedra. Por tanto, saludar su inicio, agradecer a quienes colaboran en ella, en la persona de su director, y reiterar mi agradecimiento a ICADE. Muchísimas gracias de verdad.
Muchas gracias, José Ángel. Bien, me toca también por parte de la Facultad de Derecho dar unas palabras de bienvenida, pero sobre todo quiero que sean unas palabras de agradecimiento a esta cátedra, de agradecimiento a que personifico especialmente a José Ángel Martínez Sánchez, es decir, presidente del Consejo General de Notariado y de la Fundación Notariado, que han hecho viable y han hecho posible este encuentro y este trabajar juntos a través de la Facultad de Derecho y a través de la Fundación Notariado, para precisamente abordar temas, es decir, transversales, temas puntuales, temas claves ahora mismo que nos preocupan a todos los juristas y no juristas, porque uno de los ánimos que tiene que tener toda cátedra es una enorme transversalidad donde se puedan abordar desde múltiples focos, desde múltiples aristas, todos y cada uno de los problemas que nos encontramos ahora mismo como sociedad y como personas, como ciudadanos. Y en este caso, una labor esencial que hace el notariado, una labor clave y medular en todo lo que es la función pública y ante todo los retos, los enormes desafíos que presenta la sociedad cada vez más tecnologizada, cada vez más digitalizada, y donde los juristas debemos dar muchas respuestas y procurar no ir demasiado por detrás de lo que son los avances disruptores de la tecnología. Esta es una de las claves, es una de las esencias de las muchas que va a tener esta cátedra. Esta cátedra se ha firmado hace muy poquitos meses, es la más joven que tenemos en la facultad, en la universidad, y ya nos sorprende que en tan corto espacio de tiempo ya ha sido capaz de alumbrar, de pergeñar un programa y una jornada de este voltaje o de este calibre, y además teniendo la inmensa suerte de que notarios de otros países, Italia, Bélgica, Alemania, comparezcan hoy también, estén aquí presentes, lo cual lo agradecemos muchísimo, que hayan querido estar presentes en esta primera jornada, en esta primera actividad, lo cual pues da síntoma de la fuerza que quiere y a lo que aspira en clave europea, en clave internacional, también esta cátedra, que desde la facultad queremos que colabore y que trabaje con otras cátedras, otros observatorios y otros centros también de la universidad. Mi agradecimiento también, como no, al director de esta cátedra, Manuel González Meneses. No hace falta presentarle, son las personas más conocidas en los ámbitos jurídicos y digitales y de estudio precisamente de todo lo que significa la tecnología, el blockchain, etcétera, y que desde el primer momento, conjuntamente con Segismundo Álvarez, que aquí le tenemos también, han implementado una fuerza, un carácter y sobre todo un impulso y un dinamismo muy fuerte y muy seguro, muy transversal a cada una de las actividades que tenemos. Sin más, es decir, agradecer también al Centro de Innovación del Derecho por el apoyo para que esta primera jornada sea realidad y a todos ustedes asistentes presenciales. Es decir, es de las primeras veces que volvemos a ver a tanta gente presencialmente. Ayer hubo un acto también y lo cerramos a 17 personas, no más, es decir, presencial. Nos estamos ya abriendo desde el día 13, poquito a poco, ya todo hacia la presencialidad, hacia esa, entre comillas, normalidad. Y esto es, pues bueno, el pulso de la universidad y gracias a los más de 100 asistentes que están online. Sin más, cedo ya la palabra a Manuel González Meneses, director de la cátedra.
En este momento en que presentamos en sociedad la cátedra, quiero solamente hacer referencia a cómo la concurrencia en este preciso momento de varias circunstancias justifican la existencia de un proyecto como este. Estas circunstancias que sitúan hoy a nuestro sistema de seguridad jurídica en una verdadera encrucijada son las siguientes. En primer lugar, tenemos a las puertas una sustancial reforma del reglamento EIDAS del año 2014. Ya saben, la norma europea que regula el tema de la firma electrónica y los servicios de confianza para las transacciones electrónicas, reforma que, aparte de impulsar un nuevo enfoque del tema de la identidad y de la identificación electrónica, amplía el ámbito de estos servicios de confianza relacionados con transacciones electrónicas y promueve su prestación por empresas privadas. En segundo lugar, en estos últimos años, el sorprendente y controvertido éxito de una idea que en su origen parecía muy descabellada, utópica y casi de ciencia ficción, la creación y puesta en circulación de una moneda puramente digital, al margen tanto de los Estados como del sistema financiero tradicional, mediante una red informática peer-to-peer, un programa de código abierto y un poco de teoría de juegos, ha llevado a muchos a pensar que los terceros de confianza en general son prescindibles, que la tecnología por sí sola, las herramientas criptográficas, los programas informáticos que se autoejecutan, las redes descentralizadas integradas por múltiples nodos anónimos, es capaz por sí sola y sin necesidad de ninguna autoridad o agente certificador de dotar de seguridad a la propiedad y circulación de activos digitales o digitalizados, de permitir transacciones económicas directas sin intermediación o tercería alguna. En tercer lugar, tenemos la incidencia de la pandemia, una crisis sanitaria mundial que ha venido a acelerar todo el proceso de la digitalización y de la interacción telemática. El confinamiento forzoso, la generalización del teletrabajo han potenciado la idea de que muchas más cosas se pueden hacer a distancia. Y por último, nos encontramos con lo que es el objeto específico de esta primera jornada, una directiva comunitaria del año 2019, todavía pendiente de transposición a nuestro derecho interno, que, como inmediatamente nos va a explicar Segismundo Álvarez, obliga a los Estados miembros a permitir que, como regla general, las sociedades de capital se puedan constituir y todas las operaciones societarias ser registradas sin necesidad de que los interesados comparezcan físicamente ante autoridad alguna. A la vista de una norma como esta, nuestro sistema jurídico se ve abocado o bien a prescindir de toda la seguridad que en el ámbito societario ha venido aportando la intervención notarial, o bien a reinventar la escritura pública para que la tradicional función del notario, verificación de la identidad, la capacidad y la realidad del consentimiento de las partes del negocio y del ajuste a derecho del contenido de éste, se pueda seguir prestando en este ámbito, aunque sea sin intermediación física. Pero esto segundo supone a su vez abordar el tema de la digitalización sustancial de la función notarial, porque en este otorgamiento a distancia ya no va a ser posible la firma manuscrita del documento notarial de papel. Se firmará electrónicamente un archivo electrónico, lo que nos aboca a la matriz electrónica y al protocolo electrónico y después quizá al protocolo en la nube. Creo que convendrán conmigo en que todo esto que me he limitado a apuntar bien merece una reflexión profunda y detenida, no solo por parte de notarios y registradores, sino por todos los juristas de este país, porque son muchas las cosas que aquí están en juego si tenemos en cuenta que la seguridad jurídica es un bien esencial del que todos nos beneficiamos. Y si no lo reflexionamos y pensamos los juristas, otros, ajenos a nuestras preocupaciones y valores, lo pueden estar haciendo por nosotros. Les recuerdo al respecto que la Ley 6/2020 de 11 de noviembre, reguladora de determinados aspectos de los servicios electrónicos de confianza, que ahora mismo es la norma nacional básica sobre seguridad jurídica en el ámbito digital, atribuye la competencia sobre supervisión y control de la actividad de los prestadores de servicios electrónicos de confianza al Ministerio de Asuntos Económicos y Transformación Digital. ¿Es que no tiene nada que decir al respecto el Ministerio de Justicia? ¿Es que el funcionamiento de los mecanismos que permiten atribuir e imputar las consecuencias jurídicas de una declaración negocial a una persona determinada es una cuestión exclusivamente técnica y económica? ¿No es algo que afecta más bien al mismo núcleo de nuestro derecho civil? En fin, esta cátedra que hoy comienza su actividad nace con la vocación de contribuir desde el rigor intelectual y la responsabilidad cívica a una reflexión y un debate sobre una materia ineludiblemente jurídica, pero de extraordinaria relevancia social. Un debate en el que no queremos excluir a nadie que tenga algo razonado que aportar. Notarios, registradores, abogados, jueces, representantes de la administración, del mundo empresarial, civilistas, mercantilistas, administrativistas, procesalistas, filósofos del derecho y, por supuesto, los tecnólogos, informáticos e ingenieros que nos han de ilustrar acerca del estado del arte, de la naturaleza de las cosas técnicas con las que nos enfrentamos en este ámbito. Sin su aportación, nada de lo que vamos a tratar aquí tendría mucho sentido. Y termino dando las gracias a la Universidad de Comillas, a ICADE y su decano Abel por haber creído en este proyecto, a nuestro presidente José Ángel por su confianza, a todos los académicos y compañeros notarios que se han involucrado en la actividad de la cátedra y especialmente en la preparación de esta primera jornada y muy en particular a los que se han desplazado desde lejos para estar aquí y a todos los asistentes, tanto presenciales como online, por su interés. Animo a todos a que sigan la página web de la cátedra y a que continúen acompañándonos en la aventura intelectual que hoy iniciamos.
Buenos días. Buenos días a todos. Lo primero, reiterar el agradecimiento a la Facultad de Derecho de ICADE y al Consejo General del Notariado, a la Fundación del Notariado, por la invitación y la creación de esta cátedra. Yo creo que también es de justicia decir que aquí sus dos representantes, Abel Veiga y José Ángel Martínez Sánchez, no son solo los representantes de las corporaciones, son las personas que individualmente han tenido la visión y han dado el impulso para la creación de esta cátedra y, por tanto, el agradecimiento es a ellos personalmente. También quería agradecer a Manuel González Meneses que haya aceptado llevar el honor, pero sobre todo la carga de esta cátedra. Yo creo que eso garantiza su éxito. Manuel no es solo uno de los notarios más brillantes del cuerpo, sino también alguien que lleva estudiando desde hace años esta cuestión. Estudiando la cuestión a la manera en que lo hace Manuel, es decir, con una profundidad extraordinaria y recorriendo cada eslabón y estudiando cómo la criptografía cierra estos eslabones de la famosa cadena de bloques, estudiando desde las expresiones booleanas hasta la vida de los pioneros como Turing o Neumann y de los visionarios nuevos como el ignoto Satoshi Nakamoto o el famoso Vitalik Buterin, ¿no? Yo creo que el rigor de Manuel no es solo académico, sino incluso más moral o ético. Es decir, la pasión de Manuel por su profesión deriva de lo que ésta puede aportar a la sociedad, lejos o más bien casi al contrario de cualquier visión corporativista estrecha, lo cual garantiza que los frutos de esta cátedra lo serán para el conjunto de la sociedad. Y ya paso a introducir la directiva 2019-1151. No puedo menos que dar una pequeña nota o agradecimiento especial a nuestros compañeros de otros países. La propia directiva habla del problema del idioma, es decir, de cómo la información y los modelos de estatutos tienen que estar en una lengua ampliamente comprendida por el mayor número posible de usuarios fronterizos. no vamos a decir cuál es esa lengua, aunque todos lo sabemos, ¿no? Well, I'd like to welcome especially our colleagues from Belgium, Germany, and Italy. I am going to do my speech in Spanish. I think most of you will understand, but anyway, I'll do what the directive says, so my presentation will be basically in both languages, so it's easier to follow. Por eso la presentación la haré en español, pero la pondré también en inglés para que sea más fácil de seguir por ellos. Empecemos con la directiva y su ámbito de aplicación. ¿De qué estamos hablando? Estamos hablando de la constitución online de sociedades. ¿De qué sociedades? El ámbito subjetivo, en principio, se limita obligatoriamente a las sociedades limitadas, es decir, las sociedades limitadas obligatoriamente se tienen que poder constituir totalmente online. Es posible que se incluyan también las sociedades anónimas, pero no es obligatorio, y también se pueden excluir las sociedades que se constituyan cuando las aportaciones al capital sean aportaciones en especie. En cuanto a los promotores es decir, los fundadores de la sociedad, hay que destacar que es cualquier tipo de sociedad con cualquier número de socios, en principio, que esto contrasta con el proyecto inicial de la Societas Unius Personae, que era el primer proyecto de constitución online de sociedades que hubo en la Comunidad Europea, en la Unión Europea. El segundo elemento esencial y también distinto de ese primer proyecto es que se basa en el respeto de las leyes nacionales. Es decir, las sociedades se seguirán constituyendo con arreglo al derecho interno de cada país y además también con los requisitos formales de constitución de estas sociedades. De manera que puede conservarse la intervención de las autoridades que prevea cada uno de los países en la constitución de sociedades, de los procedimientos y el contenido de los documentos que forman o que llevan a la constitución de la sociedad, y en particular sobre la autenticidad y fiabilidad de los documentos y la forma legal de los documentos, ¿vale? Es decir, que se trata de mantener el sistema de los Estados miembros tanto en el aspecto sustantivo como en el aspecto formal. Sin embargo, hay unos límites, lógicamente, porque si no, no habría ningún cambio. Y los límites son que se pueda constituir totalmente online sin la necesidad de comparecer físicamente ante ninguna autoridad del Estado, y que la presentación de los documentos que sean necesarios se puede hacer también en forma electrónica. Esto último, en principio, no plantea ningún problema, puesto que tenemos una regulación que ya permite la presentación de documentos electrónicos, y tenemos también, de hecho lo hacemos todos los días los notarios a través de las copias electrónicas que presentamos como auténticos documentos públicos en los registros. Pero lo primero sí supone, como ha dicho Manuel, un reto. Esto es de manera que se plantea la cuestión de si la participación de las autoridades, en particular de los notarios, si es necesaria y cómo se va a hacer. El considerando 19 de la directiva dice que es importante respetar la flexibilidad de los Estados miembros en la forma en que proveen de este sistema de constitución online de las sociedades, y en el articulado también se hace referencia a la posible intervención del notario. Pero esto plantea dos preguntas. ¿Por qué se prevé la intervención notarial? No se obliga, pero se permite y se prevé la intervención notarial. ¿Y cómo va a ser posible esta intervención? En cuanto a la pregunta de por qué, pues lo dice expresamente el considerando 20, ¿no? Que es para evitar el fraude y para asegurarse de la fiabilidad y credibilidad de los documentos que se contienen en los registros. Obviamente los registros mercantiles tienen la misma fiabilidad que los documentos que acceden a ellos y no más. De manera que es fundamental que se prevea un control de esos documentos. Y lo dice expresamente. A ese efecto, los Estados miembros podrán requerir la participación de los notarios en ese procedimiento. Y, por otra parte, si nos fijamos en la directiva, en el contenido de la directiva, vemos que obliga a cada los Estados miembros, o sea, les obliga a una constitución online, pero al mismo les obliga a establecer una serie de requisitos y de controles para garantizar esa seguridad. Les obliga a que se controle la identidad, se controle la capacidad, se controle la legalidad de la denominación social y del objeto, y dice expresamente que no afecta a las obligaciones de control de blanqueo de capitales. Si comparamos esto con la actuación que hacen típicamente los notarios en el otorgamiento de las escrituras, pues es con el control de la identidad, de la capacidad, de la legalidad, incluyendo un asesoramiento que supone la consecución de un consentimiento informado y, finalmente, el control de blanqueo de capitales como sujetos obligados, también impuesto por las directivas. Es decir, si bien la directiva no establece, por supuesto, no podría establecer la obligatoriedad de los notarios porque no existen notarios en todos los países europeos, sin embargo, esta idea de control tan ajustada al control que hacen los notarios supone, sin duda, una determinada orientación. Hay que destacar también la diferencia con el proyecto inicial del que hablé, es decir, con la Societas Unius Personae, que era una sociedad de constitución online exclusivamente para sociedades unipersonales y con una aplicación de una ley especial. Se ha pasado de este modelo, que por cierto fracasó y no tuvo éxito porque suponía una creación nueva sin esos controles o sin intervención de autoridades, a la directiva que ahora tenemos que transponer, que prevé una constitución online, pero siguiendo los criterios generales. Y esto nos lleva a la segunda pregunta, que es ¿cómo vamos a hacer esto? Que es lo que ya ha planteado Manuel. Pues, en fin, esto no debía salir así, pero este es el escriba, pero es el problema de cambiar las presentaciones de un programa a otro. Este es el escriba del Louvre y muchas veces nos hemos quedado con una visión un poco atada al escribano, ¿no? Al escriba. Esto tiene más de 2000 años, pero el nombre tradicional de los notarios en España es el de escribano, que sigue subsistiendo en algunos países de Iberoamérica. Y nos fijamos quizás demasiado en esto que tiene entre las manos el escriba egipcio, que es el papiro, ¿no? El documento, el papel. En realidad, si nosotros pensamos en lo que hacemos los notarios, nos damos cuenta que tiene poco que ver con el documento. Es decir, en realidad nosotros lo que hacemos es desarrollar una actividad previa de asesoramiento, intercambio de información, y en el momento de la verdad, del otorgamiento, de la firma, lo que llamamos la firma del documento notarial, la firma es realmente una parte final y muy pequeña. Lo que se hace es un control de la identificación mediante los documentos de identidad, un control de la capacidad y de la representación. Hoy, después de la Ley de Protección de Personas con Discapacidad, de la nueva regulación de la discapacidad, cabría hablar más bien un control del consentimiento, más bien del consentimiento informado que de la capacidad. Hacemos un control de legalidad que es inseparable del asesoramiento, porque nosotros no nos limitamos a controlar la legalidad de un documento, sino que conformamos ese documento de acuerdo con la voluntad de las partes, adaptándolo a la legalidad. Finalmente, se produce una lectura de ese documento con una nueva explicación del mismo que permite asegurarnos de que existe un verdadero consentimiento informado sobre un documento plenamente legal. Y en ese momento se refleja materialmente ese consentimiento informado a través de la firma en un papel por parte de los otorgantes y del notario. Por tanto, es la actividad del notario, no el documento, lo que produce los efectos. La actividad del notario, en realidad, se parece mucho más a una audiencia que a una persona que toma notas. Es decir, se trata de una actuación en la que el notario tiene a las dos partes a su lado y desarrolla un juicio, pero que no es un juicio de contraposición de intereses como este, ¿no? Como el juicio de Salomón, sino que es un juicio que alinea las voluntades de las personas en una misma dirección. Una vez que tenemos claro esto, es decir, es una idea que también manifestó José Ángel Martínez Sánchez en un artículo en La Notaría. Es decir, que la actuación del notario se parece más a una audiencia que a la redacción, a la simple constancia documental. Podemos entender que se puede existir, cuál es el cambio de paradigma al que vamos y cómo lo podemos realizar, ¿no? Es decir, la presencia física ante el notario es un medio, no es la esencia de nuestra actividad. Es lo que nos permite estar cara a cara con una persona para identificarla, para saber que tiene capacidad, para poderla informar y para saber si puede prestar ese consentimiento informado. Sin embargo, la tecnología ofrece nuevos medios, lo cual supone la posibilidad de ir a otro tipo de presencia, es decir, a lo que Manuel y yo llamamos también la inmediación a distancia, es decir, que sigue siendo una relación inmediata, pero no requiere la presencia física. Por supuesto, como ha dicho Manuel, todo esto se ha acelerado con la pandemia, es decir, nosotros hemos cambiado nuestros hábitos y nuestra cultura, nos hemos comunicado a través de las redes y a través, básicamente, de la videoconferencia, tanto para los temas personales como para los profesionales. Se ha producido un cambio, una aceleración también en el comercio, en las finanzas, por supuesto, también en relación con todo el mundo de las criptomonedas que ahora tanta importancia tiene. Y después se han producido nuevas reglas, es decir, cosas que no parecían posibles, como las juntas generales de sociedades, se han realizado de manera totalmente telemática. Ha habido incluso normas relativas a la participación de los notarios de manera telemática también en nuestro país. Esto supone, sin embargo, aunque es evidente que hay que cambiar el paradigma y que esto parece posible, supone sin duda retos. Retos que podemos dividir básicamente en dos, es decir, la necesidad de interacción sin presencia física, cómo conseguir esto de una manera operativa y segura, porque esto no es negociable desde el punto de vista del control y de lo que significa el control notarial y la contribución notarial al mundo de los negocios. Sin embargo, hay que conseguir que esto se realice, como digo, de una manera segura, pero con la misma, o con una, no con la misma, con una intensidad equivalente a la que tiene la presencia física. Y, por otra parte, hay problemas documentales a los que también se ha referido Manuel, es decir, cómo conseguir esa plasmación de que antes se realizaba mediante la firma en un papel, cómo conseguir la conservación y la inalterabilidad de ese documento en el ámbito digital. Para esto es para lo que estamos aquí, para resolver estos retos, y por eso contamos con personas de muy diversos ámbitos. Sin embargo, lo que primero que vamos a escuchar, que no hay nada, la única manera de aprender es primero escuchar, es la experiencia de nuestros colegas europeos con unos sistemas tanto mercantil de derecho de sociedades como notariales equivalentes y semejantes a los nuestros, que ya están en el proceso, han avanzado más en el proceso legislativo que nosotros. Pues nada, les animo a participar, a seguir esta jornada que yo creo que va a ser apasionante. Muchas gracias.
Good morning to everyone, and thank you very much for your participation in this seminar, either in physical presence or online. I have the honor of moderating this international roundtable that is going to deal with the transposition into national legal systems of the European Directive 2019-1151, in short, the Digital Directive, and in particular with one of its most important aspects, the adaptation to the online constitution of companies in other member states. The initial deadline set for the transposition of most of the directive has expired on the 1st of August. However, paragraph 3 of Article 2 of the directive provides that this deadline may be extended for a further year by any member state encountering objective difficulties, which should have been communicated to the Commission by the 1st February at the latest, giving some justifiable reasons. This extension has been requested by 16 member states, Spain not among them. Nevertheless, the postponement of the implementation of the directive will be the general trend, whether or not there has been formal communication, given that all the member states obviously have suffered unforeseen objective difficulties as a result of the pandemic, which has even forced the temporary closure of parliaments and government bodies. It should also be borne in mind that part of the directive has a longer transposition deadline until 1st August 2023 with no extension foreseen. That's the case for everything related to the disqualification of administrators, to measures to ensure that the origin and integrity of documents filed online in the business register can be verified electronically, and measures to ensure that information filed in the business register by companies or their branches is kept in a machine-readable and searchable format or as structured data. The transposition of the directive is somewhat delayed in Spain. By order of our Ministry of Justice of the 29th October 2019, a subcommittee was set up within the General Codification Commission with the task of determining the regulatory modifications required in our legal system and to submit a transposition proposal to the Ministry of Justice. However, on 19th April of this year, the Ministry of Justice closed the subcommittee before it completing its task, and the Ministry of Justice directly assumed the continuation of the legislative work without having published yet a preliminary draft or regulatory proposal for transposition to date. It seems, nevertheless, that a preliminary draft law is about to be published, which would respect the basic lines of the existing system of preventive legal certainty in Spain, as it has been done in Belgium, in Germany, and in Italy. These three countries, present here, are farther ahead. Germany has been the first one to complete the process with the adoption of the law for the transposition of the directive on the 5th of July, published on the 13th of August. Belgium has followed shortly afterwards with the law of 12th July, published even before, on the 15th July, and it has been the first member state to bring into practice the new online procedure designed in the law. That's why it's very interesting to have here a Belgian notary who can share with us their experience. Italy is implementing the directive in two stages. Firstly, the law of 22nd April 2021 has in its Article 29 delegated to the government the approval of the legislative decrees necessary for the transposition and has established the guidelines. The second phase is in the hands of the government and is now underway. Today we have with us three expert notaries from these countries who will explain how their national legal systems are adapting to the requirements of the digital directive as regards the online constitution of companies. Christian van Belle, notary in Ghent, Peter Stelmasik, still the director in Brussels, of the office in Brussels of the German Federation of Notaries, and soon to be a notary in Burscheid, in Rhineland.
Nordrhein-Westfalen, near Cologne.
Near Cologne. Yeah. And last but not least, Corrado Malberti, notary in Como, professor at the University of Como and before in Luxembourg, and chair of the company law working group in the CNUE. So there we have very qualified notaries who are going to talk about their national laws already adopted or in the making and the technical project for the transposition of the directive in the respective countries. Thank you very much to all three of you for your presence here today and for sharing with us your knowledge and experience. Our four countries belong to the same model of preventive legal certainty based on the intervention of notaries of the so-called Roman Germanic or Latin type, also named civil law notaries. In all four countries, the birth of a corporate legal entity and the subsequent changes during its life cycle require the guarantees of a notarial authentic instrument in the interests not only of the shareholders themselves, but above all of the third parties who come into contact with the company, whether private individuals or public authorities. Many other European legal systems are inspired by a similar assessment of legal certainty. To the 4 countries present here today, we have to add Austria, Croatia, Luxembourg, the Netherlands, the Czech Republic, among others. Maybe these countries are not the majority today in terms of number of countries in the European Union, but they are the majority in terms of population and economic importance. After Brexit, they now account for almost 2/3 of the European Union's population and also 2/3 of the gross domestic product. The reason why they are not the majority in terms of number of member states is related with the enlargement of the European Union in eastern countries, the breakup of former supranational states, and the active lobbying of the British and the Americans for the expansion of their legal system in the new member states. But however, we are still 2/3 in terms of population and 2/3 in terms of economic importance. There are, in all these countries, the mandatory intervention of the notary in the constitution or subsequent modification of commercial companies ensures the identity, capacity, and free and informed consent of all the parties. It makes possible the existence of effective systems for the prevention of money laundering. And it makes possible to give public faith to the entries in the commercial register, with the effect of simplifying and reducing the cost of subsequent relations between the company and third parties. Long and costly inquiries are not necessary here, contrary to the countries that follow the Anglo-Saxon model of merely declaratory registration. There are also important differences between one system and another. Germany, like Spain, has a system of dual control by notaries and registers, with some differences, as there is a clearly defined civil service status for registrars within the judicial sphere. In Belgium and in Italy, on the other hand, the only control of legality in company procedures is carried out by the notary, who in Italy is even responsible for registration in the business register. The directive, as has been explained by Segismundo, makes it possible to maintain the preventive legal certainty model with all its variants, as its approach to digitalization is minimalist and legally neutral. Unlike the failed draft directive on the single-member private limited company, this directive does not aim to create a new European type, but only to establish minimum common principles to ensure online incorporation, respecting the material rules governing national types of company, the formal rules on incorporation and registration, the internal public or private law provisions that shape national systems of preventive legal certainty. The only limit to all this is that it must be compatible with digital procedures as laid down in the directive by means of 3 requirements: excluding the need, as a general rule, to appear in physical presence before an authority of the member state of registration, allowing electronic identification of applicants who are European Union citizens in accordance with the provisions of European regulation on electronic identification, without prejudice to the possibility expressly provided for in recital 22 of requiring, in addition, complementary means of online identification, such as video conferencing. And third, making it possible to submit documents in electronic form and to pay out share capital online. The transposition of this directive implies a double requirement. On the one hand, some changes in the law. On the other hand, the technical development to implement the procedures entirely online. The first one is relatively simple to comply with, if the system of preventive legal security existing in our country is to be maintained. The second one is rather more complex, but it has been successfully achieved in Spain before any other country by Untitled, the Spanish notaries technological company. Our guests will explain now how both aspects have been solved in their respective countries, and what their choices have been on those points which the directive leaves to the decision of a national legislator, including whether to apply the directive to all capital companies or only to limited companies, whether or not to exclude companies formed by contributions in kind, whether or not to maintain non-digital procedures, whether or not to require the high level of security for electronic identification. And now I'm giving them the floor, starting in alphabetical order in English, by Belgium, then Germany, and last but not least, Italy. Thank you very much. Christian, you have the floor.
Thank you, Mr. Alvaro, and thank you for the invitation. I'm really honored to be here as a practitioner and a witness of the practice of this director in real. Dear colleagues, ladies and gentlemen, good morning. When we look at the European directive, we distinguish several components. The online incorporation of companies, thank you. Perfect, thank you. Voilà. The online filing and consultation of company information, online registration of branches and exchange of information between member states on disqualifications. What is the status in Belgium on these matters? The first 2 points have now been implemented in Belgium. The online registration of branches is provided for by law, but still requires an implementing decree before 1st of August 2022. The notaries themselves have no competence in this area. The exchange of information on disqualified directors between member states obviously goes beyond the borders of one member state and has not yet been implemented. In Belgium, the information on disqualified directors is not yet available for consultation in a structured manner. They are either the result of a court ruling, criminal or civil, or due to functional incompatibilities or qualitative requirements like for doctors, architects, etc. And especially regarding the latter limitations, the role of the notary as a gatekeeper and advisor remains very important. Moreover, it remains a notary's responsibility to verify the legal capacity of the entrepreneur, which needs to be checked at the time of incorporation. There is no register that offers a conclusive answer. Here's the role of the notary who has physical contact or contact via video meeting when signing act his added value. As far as the realizations are concerned, I can start with the last and simplest one, the online consultation of company information. Already in 2003, one database was created that let us actually consult our company information with all basic data of companies. This was followed by the electronic filing of acts of incorporation and amendments at the registry, at the Belgian Official Gazette, and for registration in the cross-border bank of enterprises. Through e-depot and e-griffy, actually, it's an API that was built between FEDNOT. FEDNOT is actually the Royal Federation of Belgian Notaries and the government. Two, the electronic filing of the articles of association of company quite recently are also implemented, both at incorporation and the coordination version with each amendment that are consultable actually also through a website and a database that is held by the FEDNOT. Finally, with the creation of a database of powers of representation, which is the most recent, the management of that database has been entrusted also to FEDNOT for those companies that need to be incorporated via an authentic act. The database contains all statutory rules concerning the representation of the company vis-à-vis third parties, to the extent, of course, that they have a third-party effect. As far as the online incorporation of companies is concerned, it has been a sprint for Belgium to meet the deadline. Several digital tools and processes that the Belgian notaries already had certainly facilitated this. Firstly, around 2000, the Belgian notarial profession obliged all notaries to connect to the Federation's intranet in order to stay informed of all relevant information and to use its services. Subsequently, FedNot has always focused on a further digitalization of the services and procedures within the notarial professions, both for federation services itself and for interactions with government services, and finally in their interaction with citizens. As a result, the entire notarial profession has invested in good IT infrastructure and training, which was very important also for this journey. Secondly, some 6 years ago at the Federation, she offered a secured notarial network for the entire country with an external partner that allows all notaries to organize video conferencing between offices with a high quality and a high standard of security. This was followed by an amendment of the organic law on notaries that allowed the signing of acts via video conference, in which each party at that time was with its own notary physically for the act to be executed without having to move to a sometimes more remote notary. Even as Belgium is small, this was quite important. Thirdly, the Belgian notary has been focusing on digital transformation for the past 5 years and has gained a lot of knowledge about the concept of IT platforms and customer experience, customer journeys, and also ecosystems prior to the launch of a number of successful projects. For example, we launched Bidit, an online auction platform for real estate, which was taken up very well by the market. eStocks, an electronic stock register in co-creation made with the Institute of the Accountants, which also has a nice leverage and is also included in the process of the online incorporation of companies. And EasyMe, the newest one, is a platform and digital safe for the citizens, which will also make links with other authentic databases possible, and which is at this moment an MVP, a minimal viable product, but has lots of potential. Fourthly, COVID. COVID has led to an acceleration in the acceptance of the path of digitalization. And in a few weeks' time, a legal framework was created for issuing a digital power of attorney signed at distance, fully online. This ensured that notarial acts could continue to be signed in times of lockdown without the clients having to physically come to the office. What's more, they could digitally sign a power of attorney act from anywhere in the world before a Belgian notary, also outside Europe. In a short time, everyone was obliged to adapt to video meetings and online signing processes that had to continue to comply with the character of an authentic deed. This new practice was greatly appreciated by many clients who want still now to continue to use it even without lockdown. And fifthly, since 2019, we have a revised company law in which the role of the notary as an actor for the information, modification, and restructuring and incorporation of the main company forms has been confirmed. This also has been the subject, as elsewhere in Belgium, and the mandatory intervention of the notary has been thoroughly questioned. We were therefore pleased to see that our intervention and added value, as Mr. Alvaro explained before, has been recognized. And I realize that this is a challenge that we must continue to meet and invest in. This new law already introduced a more thorough digitalization of company law, which was reinforced during the COVID pandemic. As a result, no profound change to company law was required for the implementation of the online incorporation, but an adjustment of the notarial law was sufficient. After this change, since 1st of August 2021, the incorporation of a company by an act of a digital form is possible in Belgium. In addition, the establishment online for all European citizens who have an EID in accordance with the European directive without physical appearance of the founder is possible. That's online and it's more than digital. And just like with the digital power of attorney, possible from anywhere in the world. not only for the limited liabilities companies, but for all types of companies, as well as associations and foundations that are established by Authentic Act. This can be used, unless in case of a contribution in kind, which was also foreseen by the directive, in the absence of the necessary identity checks. And for this, Belgium requires an ADAS identity of standard high quality, and risk of identity fraud, or to check the legal capacity required. Of course, this must be motivated, as the directive says. In the current state of affairs, an entrepreneur can thus opt for the formation of his company between a paper act with physical appearance at the notarial office, a digital act of incorporation with physical appearance at the notarial office, a paper or digital act via a power of attorney, whether or not signed remotely, and a digital act of incorporation without physical appearance before a notary. For the online incorporation, the Federation opted to work with a platform that is included in the law and is called Start My Business. I would invite you all to look at the website, visit it, and see what it offers. This platform is managed by the Federation, by FedNot, and includes a website with a general informative section and the formation of companies, foundations, associations, so that the citizen can inform himself about the different types of companies and the most important information about them. Apart from this informative section, in addition, he can start the online information of a company via this channel by going through various steps. We thought it important to involve the notary as early as possible in this process in order to be able to fully play his advisory role. This philosophy is present through the entire customer journey of Start My Business. For the notary, a different environment has been created on the platform that allows him to follow up the file from A to Z and also to communicate with the client through this platform. You will understand more of these issues when we go through the procedure of Start My Business, which can be resumed in 10 steps. Actually, when you go on the website, when you start the procedure to incorporate a company online, first of all, you inform yourself on the website with all information relevant to the company type that you are interested to. Then you register on the site through your identity card or other tool, confirm the IDAS standard high. Once you are registered, the process starts. You design a notary. You have a free choice of notary that are listed. All notaries from Belgium are included. And you enter the necessary data whenever they are actually ready to enter. At every step, you have the possibility to communicate with a notary once you appointed him. When a notary is appointed by a client, the notary gets notification that he is asked to contribute in the incorporation process of a new company, and okay, he has to accept or he can reject and motivate why he's on holiday or whatever. After entering the necessary data, there's space for notary advice again and communication between the clients to set up the most appropriate clauses in this deed, this notarial deed of incorporation. As the directive provides, you have a basic text with the standard defaults to raise a company, but from my experience, this hasn't been used yet, and most people try or ask for a more appropriate solution for themselves, which enforces a role and confirms our role as advisor, and lets us gives us the possibility to do adaptations or load up our own draft of deed in the system. After that, we send the draft act, we schedule a date for the video conference, we give the explanation of the act, verify if all parties have consent and are aware of what they're signing through a video meeting, like actually a physical presence, but through the screen. And then we proceed to signing the digital authentic testament, and we proceed to the post-act formalities. It says maximum 5 days, the directive, for the standard incorporations, and 10 days for the non-standard. In my experience, actually, we always try to have this post-act formalities done within 24 hours. And actually, in a few hours, the company gets a new number and can start its business. So the notary has been involved as an advisement from the start. During each phase, the entrepreneur can ask questions either via the platform or via mail. And we have the experience. I have, in meanwhile, signed about 8 with my office, 8 incorporations fully digital, and clients are quite satisfied, enthusiastic. Even are they early adapters and maybe normal that they are enthusiastic, but still it's a quite efficient tool. I would like to end my presentation maybe with a small video, 2 minutes, which is actually an interview and a testimonial of our president of FedNots, Mrs. Katrien Roggeman, and our Minister of Justice about the Start My Business platform and the fact that Belgium has succeeded to realize on schedule to implement the implementation of the directive. Yes, perfect.
Start My Business is het nieuwe platform waardoor een vennootschap volledig digitaal kan worden opgericht. Dat betekent dat de cliënt, de ondernemer, dus kan inloggen via het platform Start My Business en zo samen met de notaris zijn vennootschap volledig digitaal kan oprichten en tekenen.
Voor ondernemers moet het vooruitgaan, en zeker bij de opstart van een bedrijf. Vanaf nu zal het voortaan mogelijk zijn om volledig van op afstand digitaal een bedrijf op te richten, dankzij Start My Business. Dat is vrij uniek, want we zijn samen met 2 anderen de enige in Europa waar dit mogelijk is. En dat allemaal dankzij de inspanningen van het notariaat die al lange tijd inzetten op digitaliseren.
De band met de notaris blijft volledig, die is des te belangrijker, want er is altijd bijkomend advies dat uiteraard verleend moet worden. Bijvoorbeeld moet ik voorzien dat mijn vennootschap onroerend goed kan kopen. Wat als ik zelf als ondernemer gehuwd ben? Kan ik dan alleen een vennootschap oprichten? Het zijn allemaal vragen waar de ondernemer in eerste instantie niet aan zal denken, maar waarvoor de notaris dus beschikbaar blijft om dat advies ook ter zake te kunnen verlenen.
Het platform op zich is zeer handig om te gebruiken en daarnaast is het ook zeer duidelijk welke informatie de notaris nodig heeft om de vennootschap op te richten.
Voor het notariaat heeft het digitaal kunnen oprichten van een vennootschap uiteraard voordelen. Wij willen het notariaat ook versterken in de digitale wereld. Die evolutie is niet meer omkeerbaar, wij gaan daarin verder. En voor ons is dat ook zeer belangrijk om de mensen op die manier ten dienste te kunnen staan.
We werken allemaal heel graag op verplaatsing. Is dat nu op een zwembad, in een koffiebar of eender waar. Nu kun je dat ook gewoon in je agenda inplannen met een digitaal gesprek met uw notaris via Start My Business. En je overloopt alle belangrijke punten, de akte overlopen, eigenlijk de normale manier zoals dat je fysiek zou doen. Maar vanaf hier kan dat ook via Start My Business online om je vennootschap op te richten.
Dat betekent ook een enorme tijdswinst, hij hoeft zich niet meer te verplaatsen. En bovendien blijft de adviesverlening van de notaris, want het tekenen zelf gebeurt via een videoconferentie samen met de notaris, waardoor dus de partij en de notaris de akte digitaal zullen tekenen. Het contact blijft, dus alle garanties zijn verzekerd.
Ik vind Start My Business een aanrader.
Ja, zeker.
Thank you very much. This video was really great.
Yes.
With your Minister of Justice and with the President of the Belgian Federation of Notaries. He's acting in a very natural way.
Yes.
And let me add what you told me this morning, that the people who are there, they are real entrepreneurs. They are not actors. They were the first people to create a company online with the intervention of a notary.
That's correct.
Is that correct?
Real time and real authentic testimony of these people, which is very nice. And as the minister and ourselves were very happy with this movie, because it was a hard work to actually have this ready at the deadline. And well, we are happy to show you today as possible.
Thank you again for sharing your experience and your video. And now we give the floor to our next guest, Peter Stelmasik. Please, you have the floor.
Thank you very much, Alvaro. Do you have the PowerPoint presentation?
Niels Herbert and Maria would like to form a German private limited liability company, or GmbH, and therefore seek the advice of a notary. Is a GmbH appropriate for their needs? What requirements, risks, and obligations need to be considered? As they all live in different places, a joint personal appointment is hard to make. However, they will soon be able to form a GmbH online. All other applications for registration in the commercial register can then be made online too. The online procedure is just as secure as a face-to-face appointment, and the quality of the tailored notarial service remains the same. The notary develops the appropriate solution for all parties involved and ensures that everything is legally accurate and effective. The registration and login are made via EID. The photo is read out and matched. Niels Herbert and Maria can select the competent notary of their choice and securely transmit to him all necessary data via the platform. The notary then prepares a draft and adapts it according to the party's wishes. By means of a video conference, the notary reads out loud the act and informs all parties involved about their risks and obligations. The parties involved and the notary sign the notarial act with an electronic signature, providing the highest level of security. As usual, the notary then takes all further steps. In particular, he submits the application for registration to the commercial register. The founders are informed as soon as the company has been registered in the commercial register and thus legally exists. The proven procedure of the formation of a GmbH made in Germany becomes digital while simple and secure. Niels Herbert and Maria would like to form a
Well, they can start and form a second company, of course. Was
presentation. Yeah.
Perfect. So, thank you very much. So after this small introduction, I will now outline the general principles of the online formation of German limited liability companies, so the GmbH. Well, in 2019, as presented by Sigismundo, the European Union adopted the Digital Tools Directive. With this adoption, the European legislator really made a huge step towards bringing the European company law into the digital age. And the directive introduces the online formation of companies, but also the online applications to the commercial registers and the online filing of documents by companies inter alia. So the directive, as already mentioned, shows a very deep respect to the different legal systems and traditions. So opening clauses allow member states to tailor the system to their special needs and to their legal traditions, and in particular, they allow the mandatory involvement of the notary, whose role is really for the provision of legal certainty and the fight against abuse is expressly acknowledged by the directive, especially in the digital age. So in Germany, the legislator has also acknowledged the important role of the notary, you can say. The deadline for the transposition of the directive has already expired on the 1st of August. The German legislator asked for the requirement or for the extension of the deadline, and our system will go live on the 1st of August 2022. And it's worth mentioning that during the whole legislative process, the pivotal role of the notary for the online formation of companies has never put into question. So, since the Digital Tools Directive is it gives some leeway to the member states. It provides for the mandatory online formation of the German GmbH. And it also gives the possibility to use the online formation system for other companies of limited liability. But the German legislator decided to first only introduce it for the GmbH. So
it further stipulates that the online formation must be possible for a single founder as well as for several founders, for natural persons as well as for legal persons, and even for formation by power of attorney, even if you may ask why you need a power of attorney if there is an online formation of companies. Nevertheless, the directive permits to exclude contributions in kind, and this is what also the German legislator decided to do. So only formation by cash contribution is permitted so far. So as you can see, the German legislator has chosen a quite cautious approach, allowing to test the new online formation system in really straightforward cases. But this does not mean that the online formation is only open to a few founders, because the German GmbH is the most commonly used company form in Germany. And we have in Germany more than 1.2 million GmbHs, which is quite a huge number. And so you see the vast majority of founders will be able to use the online formation system in company law if they wish so. So far, the German legislator has deliberately not opened the online authentication system to all notarial procedures. This is based on the decision that there are divergent formal requirements in other areas of notarial law. For instance, in family and succession law, the protection of the parties involved against hasty decisions is really important. So the requirement of personal appearance at the notary's office is intended to protect the parties from premature and hasty decisions and to draw the attention to the real special importance of the transaction. In the field of real estate law, for instance, it is very common that consumers are face-to-face with entrepreneurs. And here, the notary has to take special protective measures by law, which can only reproduce to a limited extent in the online world. And so we think that the German decision, or the decision of the German legislator, to start and think small first is highly appropriate. So what were the challenges of the new system? The challenges were to reproduce the functional elements of notarial involvement and the notarial authentication procedure into the digital world. At the same time, the new system has to be, of course, easy to use and extremely secure. So that was clear to us from the very beginning of the development of our system, which we started already 3 years ago, so before even the Digital Tools Directive had been adopted. So firstly, the system must ensure the reliable identification of the parties. The notary must be able to check the legal capacity and the free will of the parties. He must be able to provide for comprehensive legal advice and preventive legal control of the formation documents. And last but not least, create a digital authentic act with probative value and as a basis for registration with the commercial registers. So that is what we have undertaken at the Federal Chamber of Notaries, and we had some decisions to take, and one part of the solution is the video conferencing system, because we think that the video conferencing system, and it's the same with Italy, Belgium, and Spain, is really the best way to reproduce the authentication situation in the digital world. So only with a video conference, the notary can check the legal capacity and the free will of the parties, cancel a digital authentication if necessary, so in case of serious doubt, for instance, about the identity of the founders, and provide individual legal advice and develop tailor-made solutions. And last but not least, check the identity of the parties via the picture. And here I wanted to go a bit more into the details of the identification system. Traditionally, in the electronic world, there are two ways of identification, which both have considerable downsides. Firstly, there's the so-called video ident procedure. So the person to be identified holds a passport, something, can be a passport or an identity card, into the camera. The problem with that here, even though the notary can compare the picture of the card with the picture on the video screen, the authenticity of the card can be easily forged and cannot be verified with certainty. On the other hand, the alternate procedure would be the mere EID procedure. Here, of course, the EID, when you put it into the EID reader, it's authentic. You cannot forge it. But the notary cannot see who is putting the card into the reader at the moment of the identification. It can be someone else. The card can be stolen, can be passed on for fraud purposes or whatever. So also psychological pressure or the legal capacity of the founder cannot be checked with a mere EID system. So our identification procedure now avoids the weakness of the two by combining a bit, the EID procedure and the comparison of a photograph of the founder. So in the first step, the EID is read out, and including the photograph that is saved digitally in the EID card or on a passport. And this way, we can really make sure that the EID is not manipulated and also that the photo is not manipulated. In a second step, then we have the video conference where the notary compares the video image of the person in the video conference with a photograph read out from the passport or the EID card. So thereby, we have a really reliable identification process. Let me show how it looks like in our new system. What you can see here is the login screen for the video conference. And to enter the video conference, you have to identify yourself via the EID. To this end, you simply have to take your smartphone, and scan the QR code, and then in the app of the Bundesnotarkammer directly opens and guides you through the process. Once this is done, the client has to place their EID, so can be a common EID, on the smartphone, and using NFC technology, the smartphone will read out all your data, and so that the notary can work with that. So in Germany, 3 electronic means of identification can be used so far. It's the new German EID card, which I have in hand here. It can be also the EID card for EU or EEA foreigners, the electronic residence permit for third-party nationals, and also foreign EIDs are accepted, provided that they have been notified in accordance with Article 9 of the EIDAS regulation, and that they meet the assurance level very high. In addition, the new German EID card and a passport can be used to read out the picture electronically. So now the second step of our 2-level identification system is as follows. You can now see the screen that the notary can see in the real system. And here is the notary, you can see it, and on the right-hand side, on the upper right-hand side, it's the client, the founder, and this is in the green circle, that's a photo which has been read out from the identity card. And here very easily, of course, the notary can compare the two, and here we would stop, of course, as a notary, the procedure, because obviously Miss Erika Mustermann, which is the person on the left-hand side, does not match the founder here. So that's the identification system. And for the remaining authentication procedure, it's carried out in the proven manner. The notary reads out the document, explains the content of the formation documents, of the articles of association, and answers the parties' questions. So in the offline world, we would now pass, after everything has been read out and explained, pass on to the signature of the parties. And here, of course, this is a problem. A handwritten signature would not work in the online world because you have a digital, originally digital instrument. And so we have, of course, to replace the handwritten signatures by a qualified electronic signature. So this qualified electronic signature is created by the certification body of the Bundesnotarkammer. It is using, therefore, the EID information from the EID card. And, well, at the end of the authentication procedure, the qualified electronic signature will be attached to the electronic document via a TIN number sent to the party's smartphone again. And this is, of course, also the assurance level high under the eIDAS regulation. And the result will be an originally electronic authentic instrument. And here, just for illustration purposes, you can see this is a TAN number here, which is sent on the to the smartphone of the client. He will put it then in on the web screen, and this is how the document is electronically signed, and the same is applies for the notary then. Yeah, and so then the video conference can be closed, and you have the original authentic instrument for the client. No additional hardware is required. You need a laptop with a camera, with a microphone, and internet, and a common standard smartphone with the NFC technology, which is really not too difficult to have. And now this video conference tool, to sum up maybe, it's only one part of the online portal, which is created by the Bundesnotarkammer. This portal allows a lot of more features. You can select the competent notary to make an appointment, provide the notary with the requisite information for the future company in a structured manner. There's a mask offered to you, and the notary can then use the platform to securely send over the documents to the parties. All documents are securely stored with the servers of the Bundesnotarkammer, so it's a closed system. There's no data leakage to other countries, for instance, the United States. If you need or use third-party providers, this is not possible. It's a closed system. And there's a checklist here. This is a dashboard for the founder. You can always see which steps you have already completed and which are still to be completed. And there's a nice little bell which can even send push-up messages to your smartphone. So finally, this is a communication between the notary and the founders. The second part of the formation process, the communication between the notary and the commercial registers, is online for more than 10 years now. So this is the same procedure. The only difference is now you don't need a paper form authentic instrument, but you have an online authentic instrument to perform the next steps, like, for instance, the opening of a bank account and the communication with other authorities. And we are working as a Bundesnotarkammer to connect our online portal to all administrative bodies and the banks, for instance, for the cash contribution, so as the notary becomes really the one-stop shop for the online information of companies. So I hope that my short introduction has given you a brief overview of the transposition of the Digital Tools Directive in Germany and a first impression of how the online information of companies will work in Germany as from 1st August 2022. And now I'm, of course, happy to discuss details with you on the roundtable. Thank you very much.
Thank you very much for your clear-cut intervention. And now we give the floor to Corrado, who will explain us the different situation in Italy, where the implementation is not yet finished. It has just started with these guidelines approved by the Italian legislator, by the parliament, and now the government has to decide how it's going to work. Do you have already a draft?
We do have a draft that was presented by the government in August. They were taking advantage of summer to hide it, probably. But we don't have a final draft, as I will explain in the presentation. In fact, and also as you have clarified before, the procedure takes 4 steps in order to have the final text. And we are currently at the 3rd step. Mm-hmm. But before I enter in the details of my presentation, let me also start with thanking, obviously, the chairperson of the panel, and to address myself to the president, to welcome the academic colleagues, to welcome the professional colleagues. I'm also a professor at the University of Trento. This is why you have this slide here. I'm a notary in Como, as Alvaro was saying. And it is a particular pleasure to be here today in this academic event with notaries probably to my understanding, the first event organized by this chair, because it is really important, in my view, to bring professionals and academics together, because academics tend to indulge in abstraction, while professionals don't have the big picture. So it is really important to have, I would say, many spaces where they can communicate with each other, where they can exchange ideas to correct these problems in their way of seeing things. Well, the only thing in Spanish in my presentation is the title. I apologize for this. I will, again, explain to you what is the implementation of Directive 1152 in Italy so far. Probably it is not just the alphabetical order, it is also, I would say, the order of advancement in the implementation of the directive. Belgium first, Germany second, Italy third, Spain fourth, I don't know, but maybe. So beyond this joke, let's start. Okay. Ta-da. Yes, if you can. Apologies for this, but these are the PowerPoints risk of preparing an online presentation. Okay, this should work. Okay, so I start with this video, which was the video presented by the Commission when the Digital Tool Directive was presented now 3 years ago. Just to remind to all of us where this started, essentially. The initial idea was to have a person from Ireland, a girl from Spain, creating a diving equipment venture in Spain. Probably they think in Brussels that this is the type of activity that can be carried out in Southern Europe without spending money, without losing time, without taking planes, with safe security checks. And essentially, this I think is important to remind to us that what is really key in the implementation of Directive 1151 is to allow this cross-border creation of legal entities, which is really challenging. The directive also, as it was said before many times, relied heavily on this EIDAS regulation, which imposes, I would say, the mutual recognition of ID certificates and electronic signatures, but it is really difficult to put into practice because technically these certificates don't really talk with each other. And I don't know if you have found a solution to that problem in Germany. If you have, tell me what it is, because it would be really appreciated to know what it is. But we should also say that another key aspect of the directive is that the national traditions had to be respected, as it was said before in the keynote speech, and that the controls surrounding the incorporations are stated really clearly, much more clearly than what it was said in the directive on company law, the codified directive on company law, Directive 2017-1132, as amended by the following directives. Now, before explaining to you at what stage we are in the implementation of the directive, it is important to highlight some points that, to some extent, Alvaro already mentioned. First, we should say that the role of notaries is quite important in Italy in the incorporation, because business registers in Italy don't carry out any control regarding the bylaws, the statute of companies. And the control they carry out are essentially controls regarding, for example, the use of latent fonts, the fact that the form is complete, but beyond that, they do not enter into the merit of the document. However, we should also say that around 5 years ago, in a kind of sandbox exercise, the government introduced an alternative procedure for the incorporation of private limited liability companies that had a specific object, a startup object clause with some R&D requirements. And this alternative procedure consisted in having the company created only by means of electronic signatures with a control carried out by the business register. As a colleague, as an academic colleague recently outlined in a report, in a presentation at the annual conference of company law professors, we had around 10,000 of these companies in Italy, but of these 10,000 startup companies, only 1/3 decided to be incorporated using by alternative procedure. So we had about 3,000 companies that were incorporated by using this alternative procedure reserved to startups. But this possibility suddenly ended in March 2021, when the Council of State said that the whole procedure, the alternative procedure, was illegal because the controls carried out by the business register didn't comply with Directive 1132 and didn't comply also with the law governing business registers. So now we are in a situation where all companies in Italy are incorporated by means of a notarial instrument, even these startup companies. And this obviously created also some repercussions in the implementation of the directive, as we will see in the following slides. Well, moving to the implementation in Italy of the directive, as I was saying before, the implementation follows 4 stages. First, we have the parliament that approves a law to delegate the government to implement the directive. The government prepares a draft decree. This happened in August, while, as Alvaro was saying, the law of the parliament is of April 2021. The parliament then issues opinions on the draft decree. This happened a couple of weeks ago. I would say beginning of October, end of September. And finally, the government adopts the decree, the delegated decree, and we are still waiting for this last step. Well, if we examine the law, the original law, we see that many of the details on the implementations were already included in that law. The government was delegated to enact legislation that provide for the incorporation online only of SRL, so private limited liability companies, not public limited liability companies. Here you have also the reference to the SRLS, which is the simplified private limited liability company, something similar to your limitada nueva empresa, that to my knowledge doesn't exist anymore, if I'm correct. Okay, we still have this in Italy. The companies that could take advantage of this online incorporation are only the companies that may be created with contributions to be paid in cash and not in kind. And also, which is probably the most important part of this article of this law regarding the online incorporation, the law expressly says that even when templates are used, the notarial form should be adopted. In any case, therefore, the online incorporation, according to the law, requires the notarial intervention. This online incorporation should take place by using a platform which should allow the video conference in a way similar to the one presented before by my colleagues, and the signing of the instrument by using electronic signatures. Again, the delegating law doesn't enter in the details of the IDAS certificates and so on. The draft decree follows closely what was required by the delegating law, but it adds something more. For example, it says that the platform should be operated by the National Chamber of Notaries. it says that the platform should enable also the issuance of electronic signatures and not just the signing of the electronic instrument online. This will allow the professional, probably the notary, to give to the participants, to the incorporators, the electronic signatures that will be then used for signing the electronic instrument, according to a procedure that is similar to the one that is going to be adopted in Germany. But another element that is interesting is that we also introduced a specification regarding the territorial competence of notaries, because in this draft decree, because in Italy we have a regional competence for notaries. So I'm a notary in Lombardy, I can pass instruments only in Lombardy, and the same for the other regions. Obviously, this creates problem when you have authentic instruments online, because persons can be online from anywhere. And the connecting factor that was proposed by the decree is that of the residence of any of the parties participating in the instrument, which this is more personal position, is not entirely satisfactory. And also, we should also say that when you have a cross-border incorporation, this criterion doesn't apply, which means that if you are incorporating, if you're a resident abroad, which doesn't make sense, you can create the company by involving any notary in Italy. The question is, what if you're a resident in Italy, but if you are abroad? Would that work or not? But this is, again, this is just the draft decree. At the same time, the National Chamber of Notaries was also working on technical solutions to, I would say, facilitate the online incorporation and the cross-border incorporation of legal entities. And we also discussed the possibility of having, of using passports for these online incorporations. Since my colleague presented many videos, I wanted to present a video as well. This is the application that was created by the National Chamber of Notaries to allow the recognition of passports using this NFC technology that we have in smartphones. Here you can see how it can be easily used to achieve the initial goal of the directive, which was really that of having this cross-border incorporation. You see, this is the app Notaio ID, which is used. It essentially says, please bring, make a picture of your passport, and then it says, bring close to your passport your smartphone, appoggia il documento sul vetro del telefono, push the documents on the bottom of your smartphone, and this is the result of reading the chip within the passport. This is something that in theory we can do even tomorrow as notaries, but we don't have the legal framework to do that. And this is also interesting because in the draft decree, there is no reference to this possibility. So second question from my colleague from Germany, do you have a specification in the German law regarding this? Because in Italy we don't, and it is not clear if then we will be able really to use that in future. But then we should say, and I come to the third stage, that we received the opinion from the Parliament, and the draft decree was criticized on several points. First point was that the platform managed by notaries was infringing Article 3 on the Treaty of the European Union, which, according to the Parliament, promotes competition. And then I should say, maybe it's Protocol 27, and don't they know the history of Article 3 and Protocol 27? But again, a small mistake, they're not expert in European law. This is not a law, this is just an opinion. And so we should forgive them to some extent. What they really want in any way is to come back to the situation we had before this decision of the Council of State with a dual track of incorporation, one using by the notaries, another using the registers. And in order to do that, in a mysterious sentence that you find in both documents of the Senate and of the Chamber of Deputies, there is this reference to the possibility that business registers should be enabled to carry out the controls provided in Article 10 of Directive 2019-1152. Probably the reference is to Directive 2017-1132, because the Directive 1152 is on temporary workers, which I think is not really related to the topic. But this is just to tell you what is, I would say, the quality of the opinion that was delivered. And clearly, notaries in Italy are really concerned by these opinions, but I mean, they come really at the very last minute. The law is clear. You should remember there is a law, not a law of 1915 as the notarial law, a law of 2021, April 2021. And I mean, I think in the end that these opinions probably would not be considered too much. And also in a conference I attended 10 years ago, the representative of the Minister of Economic Development said that probably they are not binding, they are not really requiring the government in any way on moving in some directions. But to conclude my presentation, these are the last 2 points I would like to make, is that we should really work on this possibility to allow the cross-border incorporation of legal entities, because this was the first intended goal of the Commission. I don't know if there are other goals the Commission tried to pursue, but this was the goal they said they were trying to pursue. And what I think is really more important is that after these years working on this directive, we can say that if the draft decree we have in Italy will be implemented as it is or with minor changes, we really have an harmonized incorporation procedure, as we have seen from our colleagues in Belgium, in Germany, but also in the Czech Republic, possibly in Spain. We will have a procedure that will be really similar in all member states, in many member states of the European Union. And in the other member states of the European Union, frankly speaking, it is not at present really clear how this incorporation online will be really carried out. So if we are also aiming at the harmonization of European company law, I think that the draft decree and the procedures that was proposed in Germany go really in the direction of creating a more integrated Europe. Thank you very much.
Thank you very much, Corrado, for your very interesting presentation. And now we have a second round I have some questions for all our 3 participants, but I think we are now a little bit out of the time schedule for us. So and some of them have already been answered. So I'm going to keep to what has not been said. First of all, Christian, for you, as Belgium has succeeded in keeping the high standards of legal certainty provided by the notaries in the new online procedure, and has been the first European country to implement it in practice. How are you dealing with the identification? Are you facing any problems in identifying citizens from other member states? What is the case, or what would be the case, for instance, for an Irish citizen who does not have an identity card and who has to provide a passport? Is it possible to complete the identification with a passport, as it is the case in Germany?
Well, first of all, fortunately, we had the experience by the digital proxy that was launched with the COVID, that we created then a connective digital platform to sign digital deeds that are stored in a database also held by FedNot, which will be the authentic source on a secured way. For that, we had stressed too how to proceed and to guarantee all authentic elements of this act. And one of the most important things is how to proceed to identify the person when he's appearing from you in a video meeting, but secondly also how to see how he can sign the deed and to have the integrity between the signature and the document under storage. So we had that solved. Actually, in Belgium, when we have access as notaries to the national register of all our citizens, and for that change for the COVID deeds, we also had access to the photos that are linked to the identity of persons. So actually, just by having access to these things, we can identify persons having with this direct access to this database on all matters, and the signatures included in that as well. As for the foreign citizens, that's a good question. There exists also, first of all, I would like to repeat actually that the procedure of online incorporation of companies is limited to those who have in EIDAS identification of the highest standards. So we need that, and we need also a qualified signature. We need both components. The first one at the moment, because the incorporations I had were only corporations from Belgian citizens, so I didn't have foreigners until now. There will be a connection through the Foreign Affairs in Belgium with those member states or those citizens who correspond to the high standard of EIDAS identification, to have through them actually the same control as we have in Belgium for Belgian citizens today. For now, that's not operational yet, but we have a workaround. As we had to register also foreign administrators or other foreign persons who appear in an indeed at the Cross-Bank of Enterprises, we had to create a number for them. It's like a national number of ours. It's called an RBIS number. It's a unique number that is linked to the person and matches all the mandates and other functions he has in that register. So for foreigners, we have already something like that. And through that number, when you create a number for a person who wants to incorporate a deed online through our system, Start My Business, you saw the procedure. He goes online, and there's also, he chooses a notary, so he can ask us to create a number for him. So we create this number, and when we come to the end, as with the number, there's a link with Foreign Affairs, we can check his identity and have him signed. We can't have him signed with the Belgium procedure of signing because that doesn't work. For that, we have also a workaround, that's to say an alternative solution. We are working with an external partner, Swisscom, who creates actually a digital certificate which he can sign on basis of his identity with a smartphone. In Belgium, we have also two systems of signing. You sign with your EID, that's the card, your identity card with a chip in it, and you enter your code, that's a qualified signature. And you can also sign with your smartphone through an application that's called It's Me. So that's also, that has the same value of a qualified electronic signature with your ID card. So we have the same solution for foreigners, European citizens who are qualified, conform the EIDAS qualification with the standard highest.
Thank you. That's very, very interesting. If I have understood you correctly, it's the notary who provides a foreign party with an identity number for Belgium. Is that correct?
That's correct. Actually, that's today also the case. When we have a foreigner who is appointed in a deed as administrator, we have to create a number to have him inscribed in the Cross-Bank of Enterprises. Yes, this is the same procedure.
That's very interesting, but this could be very useful also in Spain, for instance, for the tax number, but that which is absolutely required for any foreign who is present for a notarial instrument has to get it. And if you could do it to provide it in an easy digital way, it would be very, very, very.
That's correct.
Yeah. Thank you very much. The next question is now for Peter. What about the apostille? I think we've said nothing about it, but it's still there. And the question is an apostille required in your respective countries for the foreign notarial documents? Let's think, for instance, of a power of attorney. or a business register certificate that is submitted to the national notary in the online procedure? And on the reverse, on the other side, is it possible for your national authorities to issue electronic apostilles?
Can you hear me? Oh, yes. Well, I was taught a good lawyer always says, ça dépend, it depends. So I try to be one. And it exactly depends on the context where this apostille question arises. The online formation of a German GmbH can only be conducted and consequently the articles of association and all shareholders resolutions which have been adopted during the process, they don't need an apostille to be registered with the business register. So there the question does not arise. But the question of an apostille can arise in the context of the supporting documents. We have said that formation by using POAs is possible. And there, whether you need an apostille or not, depends on the country where this POA, which needs to be notary certified, comes from, has been issued. So either it's a full-fledged legalization or an apostille on the basis of the Hague Convention, or if there's an international bilateral agreement, like for instance between Germany and Italy, Germany and Belgium, Germany and Austria, there you don't need an apostille at all. If an apostille is needed, for instance, between Germany and Spain on the basis of the Hague Convention, then under German law, you still need a paper document with a paper apostille affixed to the document, to the POA, because German legislation does not provide for the possibility to accept an electronic apostille, and even more so in practice, because you want to get the company registered. The German business registers do not accept electronic apostilles. The another scenario where this can become relevant is where a company is formed by a legal person instead of a natural person. There, of course, the German notary needs to check whether the company exists and whether the person appearing for him is able or has a right to represent the company. Here, the BRIS comes into play, and in the context, cross-border context, again with Italy, Spain, France, Belgium, the notary can access the BRIS. The relevant data are reliable because they're controlled by a notary, and the German notary can then defer from the documents stored in the business registers that the company exists and that the person before him is able to represent the company. Then there's no problem at all. In relation to other countries, formerly the United Kingdom, for instance, or other member states of the European Union, where the business registers are not so reliable, I would say, because the data are not scrutinized, they are not scrutinized by the notary, then in practice the notary would need some sort of legal certificate from an administrative body or notary from this country where this company is registered, and this legal certificate from a notary or administrative body would of course need to be, again depending on the case, be either legalized, an apostille, or if there's a bilateral agreement, nothing at all. And again, in these cases, if it's a paper document, of course the founders do not need to appear in person before the notary, because this can be sent by mail beforehand. It needs some planning, but to be fair, if you plan to open up a company and start a business, it always needs some planning, and it should be able to just to send beforehand such apostilled POA or legal opinion of a notary. In the future, it is open to discussion and to which extent we can introduce the legal basis for an electronic apostille, because more and more countries are using electronic apostilles. For instance, Belgium quite recently has introduced some, and they are only using electronic apostilles. And I think there's a promise also to the European Commission to evolve and to find solutions, because as of today, there's a reservation in the Digital Tools Directive which allows the requirement of paper documents, but in the future, and we are talking about a revision of the Digital Tools Directive, there it will be, we think, required that everything needs to be online. Even we would require an electronic apostille. Thank you very much.
Thank you, Peter. I think this is something to be discussed. As you rightly point out, because in a digital scenario, I think in the future there will be a need of an electronic apostille for the cross-border constitution of companies. And we are now a little bit pressed, so I'd like to come to Corrado Malberti with what he just pointed out about Article 10 of the Codified Company Law Directive not being modified by the Digital Tools Directive. As you said, this has been recalled by the Consiglio di Stato in Italy in a recent decision. And I would like to ask you, what can be the effects on the laws passed allowing for the constitution of companies without an authentic instrument, and on the companies set up in that form? What's the situation for this? You said 3,000 existing companies. Well, or not existing companies.
In theory, they are all null and void. And the problem is, obviously, you cannot have 3,000 companies that are null and void going around. So how do you solve the problem? There were two approaches, because in the end, the problem was more a problem addressed in notarial circles, and then we had the legislation that I would say solved the debate within the notarial circles. The first approach was to say that since they were incorporated when this decision was not taken, the companies remained in existence, and only after the decision, the companies were not allowed to be incorporated in that way. And this was also the position of the National Chamber of Notaries, because in the end, they didn't want also to look too aggressive in view of the transposition of the directive. There was also a position from the Chamber of Notaries of Milan, which said that in fact the companies were null and void, but this problem could be cured with a simple verification of the bylaws carried out in any subsequent general meeting held by the company. And since general meeting held by companies can be held online, to some extent you can see this as an online incorporation procedure without EIDAS certificates and without the verifications. But finally the problem was solved by the government issuing that proposed a new legislation that was finally approved by the parliament, which essentially said that both approaches were not completely correct, and that an actual legislation was needed to solve the problem. And it said, this legislation, that these companies, even if incorporated according to a procedure that was considered illegal by the Council of State, remained in existence. But it is important to highlight that this legislation didn't touch Article 10 of Directive 1132, but one of the causes of nullity. Mm-hmm. Because this is the big difference. Even if you don't carry out the control and the company is enrolled, then it becomes, the question becomes, do you have a ground for asking the nullity of the company? In some member states you don't. In other member states like Italy, you added that possibility by essentially introducing an exception to this general principle. The legislation adopted in Italy was compliant with Article 10 without, in fact, touching the controls that were mandated by Article 10.
Mm-hmm. So if we bring this to the national level, I would say that there's no need to amend Article 20 of our law on capital companies, Ley de Sociedades de Capital, which requires an authentic instrument, a notarial authentic instrument for the constitution of companies. I think it can be considered even a bad idea if we look at the Italian example. The digital directive does not prescribe a change of our model only to make certain adjustments to notarial and registry procedures as it has been done in Belgium, in Germany, and in Italy. And with this conclusion, given that we are out of time, I just close the roundtable with many thanks to our participants and to the audience for their patience, and hoping that our discussion could be followed by everyone. Thank you very much.